This is the plaintiff, Stanley Haliva. He says he was interested in renting the defendant's theater and production space and was told he needed to leave a refundable deposit before he could take a look at the lease. Needless to say, he did indeed give the defendant the deposit, never received the lease, and now can't get his money back. He doesn't know what kind of scam the guy's trying to pull and is suing for the $5,500 he's owed. This is the defendant, Greg Slight. He says he requires a 1-month deposit along with a rental agreement to rent his valuable space. If he rejects your application, the deposit's returned. If you back out of the deal, he keeps the deposit. The plaintiff refused to provide him with the proper information and then backed out of the deal, so the money is now his. He's accused of not letting the show go on.
All parties, please raise your right hands.
And welcome back to the People's Court. Next case on the docket, the plaintiff was thinking of renting the defendant's theater and claims that he got stiffed. But the defendant is saying that the plaintiff flaked in the deal, so bye-bye deposit. It's the case of how to fail in business without really trying.
Thank you, Douglas. Okay, Be Someday Productions Incorporated?
Yes.
You are suing Greg, you pronounce it?
Slight.
Slight. You are suing Greg Slight. You've asked us not to mention the name of the, is it a property management company or it's just your investment company?
It's just me.
Okay, it's just you. It's you, all you. For $5,500, $1,500 because he kept your security deposit and the rest of it in treble damages and attorney's fees. Tell me what's going on.
Well, I'm a director at a small nonprofit theater company.
A theater company?
Theater company called Be Someday Productions.
And tell me about the name Be Someday.
Well, we just feel it's like empowering. We do a lot of work with the community, with youth, with children.
Okay.
And so we are on Frankfurt Avenue, Corridor of the Arts, and we are outgrowing our space. And we were looking for a space to expand into, but we wanted it to be on the Corridor of the Arts. And it turned out that we saw the for rent sign in Mr. Slight's building, which is just down the block from us. And so I went, took a look at it. I met him and we liked the space. I asked for a copy of the lease. And then Mr. Slight told me that before he could give us a copy of the lease, I had to give him a security deposit.
That sounds odd.
Yeah, okay. I thought it sounded odd too. But as I handed him the check, he said, don't worry. If for whatever reason I don't like you, you will get your deposit back 100%. And then he said, I'm not into stealing the people's deposits. And he laughed.
Oh, did you actually demand $1,500 to even see a lease?
No.
Then why,
I supplied the lease prior to that. He asked for a copy of the lease. I supplied him with a copy of the lease. No questions asked. I just gave him
But see, normally I wouldn't see your side with a security deposit in their hands until after the lease was signed and business was, the handshake was done and the deal was struck.
The way it normally works is that the deposit is paid when the rent application is put in. And then the balance of that, which is the first and last month's rent, is paid when the keys are handed over.
Okay, you can do business any way you want, but that's not the way it normally is done. But
well, in Philadelphia, that's the way it's done.
That's fine. Okay, so whatever. So according to you, what is the agreement on the refundability of this deposit, security deposit?
The agreement on the refundability is if I decide I don't like him as a tenant, if the application is deficient or for whatever reason I reject him, I return his deposit 100%.
Okay, all right, so what happens?
Well, we never did see the lease. And then he sent me emails asking me for more information for the application, which I supplied to what I thought was the best of our ability to. And he said it was continued to be deficient. He said our application was deficient.
Well, what did you supply?
I supplied a copy of our company's previous year's tax return.
Okay,
yes, for the current year's tax return, but
you hadn't prepared him yet.
But we had not prepared them yet. Okay. Also in there
You're just going to hand over your whole file? I just wanted to see what you handed him.
Those things in there are things that I gave him as more information when he asked for more information.
Okay. And then he says this isn't good enough.
He said it was not.
What was the
Actually, what he said was that we didn't give him anything but an EIN number.
Okay. Did you not get this or was this just not enough?
I didn't get that.
How did you send this?
I sent it by email as attachments.
Can I see the email? While he's looking, can you come up? What's your name?
I'm Michelle Pauls. I'm
And what's your
Stan's
role?
partner and wife
Oh, and wife.
in
Okay.
the theater company.
Okay. In response to your email to him that he only gave you an EIN, he responds, not true, that I only gave you an EIN. I also, an employer identification number. I also gave you an annual report compiled by an independent auditing firm. If it's good enough for the IRS, I think it should be good enough for you. I guess you don't like the tone of that or whatever because you send back an email. I think the IRS and I have different concerns, true. I'm concerned with accountability and liability. Also, why did you not answer the question about bankruptcy? That's 2 days later. So clearly when he says, I also gave you an annual report compiled by an independent auditing firm, you do not say, no, you didn't. You say,
I'm not, except it wasn't an annual report. It's a financial statement and it's 2 years old. It's 2 years old.
so what else did you want? What else did you want?
Well, at that point, I was willing to go forward, but you don't understand. You have to understand the sequence. The next email that came to him after I explained the accountability was, I don't want your space. This long, in capital letters, screaming email accusing me of all kinds of things and speaking to me in a very disrespectful tone. At that point, it was over. He said he didn't want the space, and I said, fine.
I know exactly what happened. I'm going to tell you exactly what happened. This is what we call ¿Quién es más macho? Okay, that's what happened.
Exactly.
And let me tell you part of why it happened, because I find it fascinating, because you're two grown men. But this is, I tell this all the time to my children, who seem to communicate only through text and email with everyone in the world, that there is something about that medium that is icy and impolite. So what happens is in this medium, when we communicate electronically, is that we lose our human compassion and you don't see the tone of the other person, so you don't know how they're delivering it. So you give the curt statement, not true that I only gave you an EIN. I also gave you an annual report and compiled by an independent auditing firm. If it's good enough for the IRS, I think it should be good enough for you. That's not that polite. I got to be honest with you. All right. Then he responds, I think the IRS and myself have different concerns. I'm concerned with accountability and liability. If it ended there, that would be polite. But what is it? Also, why did you not answer the question about bankruptcy? Back. So then we have, and there's no capital letters in, so I don't know why you say he's shouting, but it is a very wordy 2-page email. You did not ask me a question about bankruptcy that I know of. Meanwhile, we've given you plenty of info. Not just the IRS, but any business that I know of other than you would find a financial statement compiled by an independent accounting firm to be sufficient. But for some mysterious reason to you, it's nothing but an EIN. I don't get it. We've been successfully in business for 15 years. Nonprofit for 8. Blah, 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 blah. And you, for all that, you seem to be angry at us. I got to be honest with you. You seem a little angry at him. You seem to be angry at us for some reason I don't understand, except maybe you failed to exercise due diligence on a previous tenant. You seem to feel we are vagrants or scofflaws. Then there's a bunch of accusations about him lying about a bunch of stuff. Then it's Monday, you said you need a deposit with the app or you can't show us the lease. Really? Nothing's changed in 2 days other than your story. I could go on, but what's the point? You don't seem to think we'd make good tenants. Fine, send the deposit back today, and we'll move on. Frankly, we don't think you'd make a very good landlord either. Okay. Now, tell me your reason for keeping the security deposit.
As I stated, whenever I negotiated with him for over 3 months with this. Deposit is a deposit in good faith. It holds the parties to the agreement. If I decided
I wrote down exactly what you said at the beginning. If for some reason the application is deficient or for whatever reason I reject him, he gets it back.
That's fine, yes.
Word for word.
Yes.
All right. According to you and all these emails and your testimony, the application was deficient. They stopped giving you what you wanted to get. Why are you keeping
because
the security deposit?
It's not because I hadn't rejected the application. It's a process of collecting the information.
This numerous email after email telling him you're not giving me enough.
Well,
isn't that you calling the application
deficient? I believe I have the right to ask for additional information. If I find that he's not giving me enough, like not answering a bankruptcy question, there's 8 questions on the second page of the application. It's very conspicuous when someone doesn't answer one of them.
Okay, so only 2 things could possibly happen that would cause you to give the security deposit back. You reject him,
right,
which was about to happen, or you say the application is deficient, which you said repeatedly in your emails. So on what grounds are you keeping the security deposit? I'll tell you what grounds. Bad ones. All right, now you're suing for treble damage. Are you the lawyer?
Yeah,
Step on up. I normally don't let the lawyer talk, but I want to have a chat with you. Come on up.
It's a wise decision, Your Honor.
Come on, step closer to the microphone.
got it.
All right.
So, I love asking this question. Who abuses the system more, landlords or tenants? What do you think?
Landlords.
Why do you say?
Well, because they usually file things against tenants after the tenants have left.
You're a tenant.
Obviously.
Okay. What do you think?
Definitely landlords.
Why?
They're just creepy and they don't respect the tenants. They just want the money.
Creepy landlords. What do you think?
Definitely landlords, because they make the rules, so you have to follow them and pay the money.
Okay. Spoken like true tenants. Going inside the courtroom.
Now, you sent a lawyer letter, which was a really good lawyer letter, I got to tell you.
Thank you, Your Honor.
It really was. But at the end of that letter, you threatened treble damages.
Yes, Your Honor.
Why don't you convince me how this qualifies as treble damages? Or would you like to take a pass on that?
I can explain the law in Pennsylvania, Your Honor, if you'd like to hear that.
Go ahead. Yeah, let me hear it.
In Pennsylvania, there's a law called the Unfair Trade Practices and Consumer Protection.
And what does that govern?
That law governs all consumer transactions, including lease agreements.
Lease goods or services?
Yes.
Primarily for personal, family, or household purposes?
Yes, Your Honor.
How would that cover real estate transaction gone awry?
In Pennsylvania, there's case law. Monumental Property is the name of the case. I don't have the citation on me.
You have it?
No, Your
This is
Honor.
a business-to-business
Don't
agreement.
worry about it. Just let me do my job.
Your
Do you
Honor,
have it?
I haven't the case on me. I have the citation in my pocket, and my cell phone, which
I
is
don't
turned
find
off.
this. I don't find this to qualify for treble damages. It's a good threat at the end of your letter, so because it was a good letter. But this is not the kind of situation where a court should be awarding treble damages for some kind of fraud on his part. It was a business decision, and frankly, your client sort of walked away angry. I hope you guys didn't really want it. I hope the board didn't really want it, because I sort of think that he was a little angry a little soon, and but at the end of the day, you called the application deficient repeatedly, and I find that you have to return the security deposit, $1,500, verdict for the plaintiff. You don't have a right. Why would you have a right to $1,000 in attorney's fees for writing a letter?
Because this was scheduled to go to trial, Your Honor, under the Consumer Protection Law, there's also provision to recover attorney's fees and court costs.
Okay.
And I was taking this case as a contingency case, so for the time invested in
But on what
research,
statute? On the
writing-
same statute that I'm
The
finding?
same statute. I have a copy of the statute here.
Wait. The fraud statute?
Yes, Your Honor.
Yeah, goodbye. All right, so $1,500 verdict for the plaintiff.
Plaintiff doesn't get triple damages, but they get back something. Step in here. As the defendant losing here, what's going through your mind coming out here?
I'm just glad to get it behind me and move on. It's a neighborhood issue. There's other people, in that area, and I'm glad that everything worked out the way it did.
Mm-hmm. So who's in there now instead of them? Who's in the property now?
I lost 3 months worth of rent, and I finally got a tenant. I got a good tenant. I've always rented to artists. That's always been successful to me.
Okay. All right. Good luck. You head right around the corner there and come on in here. Tell me what you think about what you got out of this case. You satisfied here? Well, she is, but what about you?
I'm pleased. We got what we always wanted. We just wanted our security deposit returned, and took a long time to get it, but we're glad that we got it.
I mean, we never even moved into this building, right? If you give a security deposit, if you move into the place.
Why'd you give him $1,500 before he saw the lease?
Well, because he said,
thought it was a
I
great
need
place."
$1,500 before I could show you the lease.
So what have you produced?
What have we produced? Well, we do a lot of family theater. We have an educational outreach program called Of Mythic Proportions that just won the Barrymore Award for educational excellence in Philadelphia.
And we do a lot of literary adaptations and original work, edgy kind of stuff, theater. And, we're on the Frankfurt Avenue Arts Corridor.
All right, let's wrap
on
it
the
up.
frontier.
Harvey?
So these laws on landlord-tenant vary from state to state. You can go to your local bar association. A lot of them offer free or low-cost consultations where for a half hour you can at least figure out your legal rights. That will do it for this case. Litigants for the next case underway into the courtroom right now.